Okay, so today's conference is about evaluating how European institutions did in the crisis, and the financial crisis that started around 2011 affecting sovereigns and then went on till 2013, 2014. And there have been many papers written about the need for European institutions to do a variety of things and evaluating whether or not those institutions did them correctly. And one giant gap in the evaluation of those institutions has been the role of the courts. Because in so many of these institutional responses, courts have had a role to play. And the question that we were interested in, I was interested in, was whether or not the courts actually performed the role they were supposed to. Now, Georg is an expert on courts and looking at how courts deal with crises, although perhaps had not really looked at financial crises, and I look at financial crises, but hadn't really looked at how courts dealt with it. So we started talking, and I'll turn it over to Georg to sort of talk a little bit about what we looked at and the kinds of questions we were interested in and where we've gotten to.
Yeah, well, maybe just to add a little bit to what you were saying, it's not just that courts played an important role in the response to the crisis, it's also that, and not just in this particular crises in general, some of the lessons learned are to reform rules, to create new kinds of constraints that might prevent crisis in the future. And typically one of the elements of those constraints is a reliance on courts in the future to enforce them when push comes to shove. And so the question for us really was, are courts likely to do that? And our short answer is, there are some significant limitations to judicial enforcement.
So one question that I think hasn't been asked and is not really being asked yet at the conference, although we will certainly talk about it, is whether or not most of the evaluations of how well European institutions did have taken for granted the performance of the courts. Because there's almost, if you look at all of the papers being presented today, most of them sort of just assume that courts will rigorously enforce rules. And that raises the question, is that assumption really valid? Do courts during crises rigorously enforce rules?
And I think sort of our expectation is that there are institutional features of courts that place some limits on their ability to do that. In particular, courts are institutions that have very few direct enforcement mechanisms, and as a result, they have to rely on others to implement their decisions. And the pressure to do so typically comes from the perceived legitimacy of the court. And so that makes courts and judges sensitive to their perceived legitimacy. And in crisis situations, the fact that courts or judges may come to believe that hamstringing governments will put them in a difficult political situation in which they're potentially going to be blamed for prolonging or deepening a crisis, may limit their willingness to step in.
So let's just very briefly talk about one of the classic rules in the European area and in the European Monetary Union in particular. So the classic rule is the no bailout clause. And the no bailout clause, although now some people say is a wobbly, weak thing, initially was intended when no bailout is just a rule, no bailout. And so if we could talk a little bit about sort of how that was implemented and how courts dealt with the no bailout clause, and particularly the interaction of the German Constitutional Court and the European Court of Justice, maybe that will help illustrate our point.
Sure, well, I'll start and then I'll let you take over since you are the expert on this. But the German court certainly in its first decision on the OMT crisis and the no bailout clause raised significant legal objections or at least concerns about the program. And so in that sense, I think there's some reason to think that there might have been legitimate legal reasons for thinking that this program was not one that was consistent with the original intention behind the no bailout clauses. And you can tell us what happened ultimately.
Yeah, so I mean, this is how our conversation started, and then the paper got going, which was the no bailout clause seemed to most observers, and I think was intended to be or understood to be in many countries, particularly in Northern Europe, a strict rule. And the OMT program, famously implemented in a speech by, sort of at least articulated in a speech by Mario Draghi in 2012, seemed to be inconsistent with this no bailout clause. And so it goes before the German Constitutional Court, a very powerful, highly respected court. And the German Constitutional Court says, you know, it looks like this program is inconsistent with the conditions under which Germany has entered into the European Monetary Union. So you might think that was it. The court says no. But in this very peculiar context, the German Constitutional Court says, we don't really like it, we don't think it's right, but then they send it over to the European Court of Justice. Mm-hmm. And to me, that's what is interesting. Sort of, you have a strong court that says the rule is being violated. We think so strongly, yet we don't really want to decide
ultimately,
it. And we'll send it to another court whose authority we're not sure we actually have to accept. So then you tell us the rest of the story in terms of what happens and how this is relevant.
After the European Court of Justice receives the case and considers it and issues its judgment in which it says no, the OMT program is compatible with European law and the European Central Bank's mandate, the German Constitutional Court ultimately backs down and does not return to its original staunch opposition to OMT and leaves the program intact. And so I think there are a number of ways you can think about that court decision, but for us, it's potentially illustrative of a strong court that decides, in the face of the potential financial turmoil, of sticking to its legal opinion, that it would prefer to back down, which for us is or highlights the potential that courts may not be ultimately the kinds of enforcement mechanisms that we often think of them as being.
So this sort of raises the bigger question as to whether or not, when you're designing a system, you can depend on courts to rigorously enforce rules like the no bailout clause, particularly when you have deep financial crises. And I think one of the potential lessons, although much more research is undoubtedly required, one of the potential lessons is that courts are not the kinds of institutions that, when faced with such crises, are necessarily in the best position, either in terms of willingness to do tough things or capacity to do tough things, to enforce tough rules. And often their inclination is going to be to convert the rule into a much more malleable standard. Now, if you wanted a standard in the first place, that's fine. But if you wanted a rule in the first place, then don't blame the court when the rule is converted into a standard. No. So, but anyway, thank you.
Thank you.
Thank you.